Yes.
Aisha.
Yes.
Good evening, senior.
Good evening.
I wanted to tell Council Aisha to admit the people because I don't know them. I don't know those who are supposed to be here.
Okay.
Yes.
Okay. So now, when we are dealing with insolvency, we've said that the word insolvency, we have two categories of insolvency. One, insolvency of a company and insolvency of an individual. Sometimes insolvency of a company is also known as corporate insolvency. So when you are dealing with insolvency, what factors you should put into consideration? We are going to summarize this basically using issues. These issues, they are going to be cutting through the entire workshop 1 and 2. They are the issues you should raise in both workshops. So let's start with issue 1. So when you are dealing with either an individual or a corporate entity, the first thing to determine is whether there are any insolvency situations. So what we have first understand what amounts to insolvency situations. Let's go to the Insolvency Act. Make sure you have it as amended. Don't risk. Okay. So when you are dealing with insolvency situations, they are under Section 3 of the Insolvency Act. Those are what we call insolvency situations. Okay. Insolvency situations. When you look at Section 3 of the Insolvency Act, it is to pay debts. So for a company or an individual to be dealt with under the Insolvency Act, it should have what we call insolvency situations. Okay, so Section 3 says that 1, okay, that section wasn't amended. It says 1, subject to subsection 2, and unless the contrary is provided, a debtor is presumed to be unable to pay debts if a debtor has failed to comply with the statutory demands. So the first factor we consider and come to the conclusion that there exists insolvency situations where you have been served with a statutory demand. So the question is, what amounts to a statutory demand? Then you go to Section 4 of the Insolvency Act. Was Section 4 amended? It wasn't also amended. So you can be given facts. When you see any of the following, it amounts to a statutory. So you should understand that if your client has been unable to satisfy the statutory demand, then that means your client is facing insolvency situations. Okay. Then Section 4 says that a demand by the creditor in respect of a debt made in accordance with this section shall be a demand notice and shall constitute a statutory demand. So the first thing is a demand notice. Once I serve you with a demand notice and you don't comply, that means you are unable to pay the demand. You are facing insolvency situations. Then 2, a statutory demand shall be made in respect of the debt that is not less than prescribed amount, and in the case of a debt owed by 1, an individual, section 4, subsection 2. Okay. A statutory demand shall be made in respect of a debt that is not less than the prescribed amount, and in case of a debt owned by an individual is a judgment debtor. So also where you have judgment, remember from a judgment we get a decree. So once we serve you with a judgment debtor, you have not yet fulfilled your obligations under the judgment. That means you are unable to pay the demand. A judgment is also a demand. It's a statutory notice because it has amount prescribed therein that you're supposed to pay. Okay. Then a company is an ascertained debt, but need not to be a judgment debt. A company where it is any other type of a debt, regardless of not being a judgment, it can also be a demand. Then B, it should be in the prescribed form, except where the debt is a judgment debt, be verified by a statutory declaration attached to a demand. Okay. Now, where it is a judgment, you write your ordinary letter, these demand letters, you should accompany it with the statutory declaration. Okay. Why are they saying that a statutory demand should be in a prescribed form? So that means if it does not comply to the form set out therein, does not amount to statutory demand. Okay. Are we together? We go on. Okay. It should be served to the debtor and require the debtor to pay the debt or compound with the creditor or to give a charge over property to secure payment of a debt to a reasonable satisfaction of the creditor within 20 working days after the date of service or longer period as court may order. Now, they will give you a notice when it is below 20 days. Okay? When it is below 20 working days, it doesn't amount to demand. Okay, it says, okay, within 20 working, and respond. Under insolvency, my dear, it should be 20 days. Yes. Okay. And it should be accompanied by a statutory declaration. So that is the first thing we look at, and we say that Mastula is having insolvency situations. That's the first one, where you are unable to satisfy a statutory demand. Yes. Okay. Then we go back. Okay. The first one we've been looking at is inability to satisfy a demand or a statutory demand. So if it's not a statutory demand, what else amounts to insolvency situation? Then you go to B. 20 days. The time within which to respond. You know, you'll be deemed to be unable to pay the debt. You've not yet been declared. Okay. Then B, the execution issued against the debtor in respect of the judgment debt has been returned unsatisfied wholly or in part. Where a decree has been sent to you for execution, let's say the decree is demanding you to pay 200 million shillings, and all your assets are worth 500 million shillings. That means the decree is for 200, your assets are for 500. It can be settled. But where the decree is of 500 and your assets are worth 200, can you satisfy that decree? That means you are unable to pay your debts. We shall come for you. Okay? Then another one. Are we at the same page, Collins? Okay? We are still dealing with our issue 1, which says that whether there exists any insolvency situations. We said that what amounts to insolvency situations is described under section 3, what we call inability to pay debts. Section 3 gives you the different circumstances under which you may tell that this person is unable to pay debts. Okay? The first one, where you can't satisfy a statutory demand. And we went ahead and understood what amounts to a statutory demand under section 4. We said 1, it can be judgment, it can be demand notice, but the demand notice should prescribe an amount and time within which it should be paid. The time should be no less than 20 days. And if it is not a judgment, it should be accompanied by a statutory factor which amounts to inability. What we've been looking at is what has been issued and it has been returned unsatisfied, where a decree of execution has been issued, okay, has been issued, and you can't realize that it has been returned unsatisfied. I gave an example that where a decree has been issued, okay, and the amount therein is 200 million shillings and your estate is of 50 million shillings. That means even if you collect everything you have and you yourself, you can't satisfy that. So that means you are unable to pay your debts. Okay, so we shall see the way forward after that. Okay, are we together?
Yeah.
Then another factor we consider, we say all or substantial all the property of the debtor is in possession, control of a receiver or some other person enforcing a charge over that property. We have people who know how to borrow. Okay. For him to die without money, yeah, he rather gives out all his assets as security than staying with an asset. So where you also borrow that person money, you want to enforce. You realize that the phone, Aisha has it here. The book, Mastula has it here. The house, Standard Chartered Bank. The car, Pride Microfinance. It is only him without a yen. Okay, so all his assets, he literally has nothing. Okay, so that means this person is unable to pay his or her debts. Okay, are we together? Okay, so now when you look at that, they can give you any of the 3 things we've looked at in the facts for you to base on to determine whether this person is unable to pay his or her debts. Okay, so for you, what you should do that Aisha she is suffering from what we call insolvency situations. Are we together? Very simple. So once you understand that, you come to the conclusion that this person is suffering what we call insolvency situations. But as you know, the framers of this law, okay, hate someone being declared bankrupt or a company being subjected to insolvency proceedings. Okay, it's like the way divorce is inevitable, but Allah hates divorce. Not so, but it is subjected to in rare of the rarest circumstances. So before you come to the conclusion that you're going to divorce, there are things you should first go through. Even in our secular law, before you come to the conclusion that you're divorced, we have a difference, not so? That time, what if things work out? Why? The law hates divorce. So the same way the law hates divorce, the law hates insolvency proceedings. So after ascertaining that your client, whatever client, whether an individual or a company, is suffering from insolvency situations, but you as an advocate, you are under an obligation to protect this company so that it is not subjected to insolvency situations. Okay? So then you ask yourself, what interim remedies are available in the circumstances to protect the company or an individual? Okay? You have not yet reached the conclusion that we are going for this. Okay? Because the law hates insolvency proceedings. That's the naked truth. Okay? Because imagine if she has a company, she's employing 60 people. Okay? 60 people. The 60 people she's employing, everyone goes home. When they are approaching home, they buy from mama and what have you. No, so, and Mama Brenda gets money. Mama Brenda also goes down to Masaka using the same money. That's what we call the as well. Once Mama Brenda suffers the same, the farmers in Masaka, if the farmers suffer, the people who sell insecticides and all agricultural produces and how will they survive? They also have families. So to protect that chain, the law hates what we call insolvency. So as a result of that, the law has put into place different measures to ensure that an individual like a company do not reach the extent of being subjected to insolvency situations. So the first one, once you read the facts, you understand that your client is suffering insolvency situations. And one of the situations is that this person cannot satisfy the statutory demand. Mark this, choose the remedy wisely. They will give you facts where this person was not issued with a statutory demand, and you go for that interim remedy, which is not applicable. Okay, so why you see that your client was issued with a statutory demand, what's the remedy? The remedy is known as setting aside a statutory demand. Why? You see, the amount that is disputed. So let's go to setting aside a statutory demand. Section 5 of the Insolvency Act. Okay. Section 5 of the Insolvency Act is very emphatic. It says that court may, on application of a debtor, set aside a statutory demand. So we want to know what factors you base on to say that I'm going to set aside a statutory demand. Okay. When you look at section 5, subsection 4, sets out the factors. Says the court may grant an application to set aside a statutory demand if it is satisfied that A, there is a substantial dispute whether the debt owing or is due. They will give you facts where she says, where I have served her with the statutory demand, saying that I'm demanding her 500 million shillings. But for her, she says, Mr. Ram, I remember I gave you 500,000 shillings. Okay? This 500 is creating a dispute. So that means the notice doesn't comply to section 4, because under this should prescribe, should demand the exact amount. So once you have a dispute in regards to the amount, it is a ground of setting it aside. Okay? Are you together? Yes, regarding amount. Then 2, that the debtors appear to have a counterclaim set off a cross demand, and the amount specified in the demand less the amount of the counterclaim set off or cross is less than the prescribed amount. What does this mean? Okay, you've served with a demand, okay, but I also demand you. Okay, I also, so that means I also have a counter claim or a cross demand. But the money I demand you, if we make a set off like this, chances are high I'll be the one demanding you. Okay? So where I also have a claim against you, I can set aside that demand. We can't settle. But once that demand is not set aside, it stands. Okay? Then another factor, that the creditor holds some property in respect of the debt claimed by the debtor, and that the value of the security is equivalent or exceeds full amount of the debt. Okay, what does this imply? Okay, the third factor, that I gave him, he gave me a loan, I gave him security. My security is land comprised in Chihuga, block 5, plot 10, which is worth 500 million shillings. He gave me a loan facility of 20 million. So he has my security of 500 billion shillings. So you want to demand me. You said you made demand notice. On what grounds? Okay? On what grounds? Because even if I decide to sell off that property, I can pay your debt, I buy your house, I buy your car and your entire family. Okay? So they'll give you such facts. And I know that is coming. The last one. Then, okay, then lastly, okay, that the demand is ought to be set aside on such grounds as it deems fit. That's what we call on justifiable grounds. Those ones we also don't know. Okay. So now the question is, when do you make this application? When do you make the application? You come back to section 5, subsection 2, paragraph A. It says that be made within 10 working days after the date of service of the demand. So you count the time. If you are past 10 working days, that means you are out of time. Okay? And you've seen how these fund applications appear in your IAs. The last one, this one, now even the last one. Okay, it's section 5, subsection. How do we make this application? Is it by notes of motion? Is it by chamber summons? Is it by originating summons? When you go to the what we call insolvency regulations, you go to regulation 6. It tells you how we apply for setting aside. It says that application to set aside a statutory demand. An application to set aside a statutory demand under section 5 of the Act shall be made by notes of motion. So that means it is by notes of motion supported by an affidavit. So now we presume regulation 6. So now we presume the demand has been set, still insolvency. So what other remedies can we take on? Okay. Now the challenge is because I want to do corporate, insolvency, and then individual at the same time. But you people don't have the Companies Act, so it's a little bit hard for me, but we shall find means, don't worry. Okay, now let's go to other remedies. Let's start with remedies in individual insolvency, where it is you, an individual, being subjected to insolvency proceedings. Okay. Yes, yeah, it can be issued both parties. Okay. Okay. So one, remember the persons who are oppressing you are known as have a lot than how you think. Okay. That's why when you are looking at types of retain the debtors, or what we call voluntary. Okay. But once the creditors come into play, my dear, you can't survive. Okay. So let's look at what we call the different remedies that we have. Yes, after setting it aside. Okay. Okay. And you first set the demand aside before you do anything else. Okay. So now we presume that the demand has been set aside. What do we go for? We have what we call arrangement. Okay, it's the second one. Arrangement. The first one was setting aside a statutory demand. Then the second one is arrangement. We are still dealing with that. We shall list those other companies. There is arrangement, but it's different from this one. Okay. Now, let's go to section. Okay. So let's go to 119. So the first one, the first thing, when you say I want to go for arrangement, you first get what we call the interim protective order, which acts as an injunction. Okay? If your intention is to go for arrangement, first make an application for an interim protective order. Before we drive to the law, what do you understand by the interim protective order? Remember, I've told you that the creditors have a lot of energy. Have you ever demanded someone? When you are broke, if this person doesn't fit, I show me your phone. I will call you, say, Mastur, yes, it is me. I will put in my money. And you know very well, I have screenshots that can ruin your life. Send my money. That's the power of a creditor. When someone wants money, okay, make sure you give that person his or her money. So to avoid such, when it comes to insolvency matters, first get the interim protective. So this order protects you from the pressure. You can even relax and buy soda. You start posting on WhatsApp. Yes, I'm broke, but if you find me taking chips and chicken, I'm not broke on myself. I'm broke because you have the interim protective order. So let's go and understand it via the law. Section 119. Okay. This is the simplest in corporate. Okay. It says a debtor who intends to make an arrangement with his or her creditors may apply to court for an interim protective order. So you see, the factor, the determinant factor, are you going to enter into an arrangement with the creditors or not? So if you have the intention of entering into an arrangement with the creditors, then you get the interim protective order to stop them. Okay? Then what are the factors court considers before they grant the interim protective order? We have section 120, subsection 2 is very emphatic. Court may make an interim order under section 119 if it is satisfied that A, the debtor intends to make an arrangement okay. It says that the debtor intends to make an arrangement, and where the debtor is undischarged bankrupt, he or she has given notice of intention to the trustee of his or her estate. Okay, so the first thing they consider, are you intending to enter into an arrangement with your creditors or not? Okay, that's the first part. Section 120, subsection 2. Then another one, that a named insolvency practitioner is willing to act as a supervisor of the proposed arrangement. Okay? A named insolvency practitioner. So that means you have appointed, okay, a prominent insolvency practitioner, okay, is willing to act as a supervisor. Then another factor, a debtor is an undischarged bankrupt able to petition for his. Okay, I told you the intention of the protective order to protect you from creditors. Okay, but it doesn't protect you from yourself. Get it? Okay, the debtor is able to petition him or herself. Okay, you can take yourself to court peacefully. Okay, then another one, that the previous application has not been made by the data for the interim order within the last 12 months. That you will not go to court when creditors are overtaking you for the last 12. So that means you can't just run to court every year. But please protect me from creditors. No. That means you don't want to pay. Yes. Okay. And then lastly, that the data's purpose, that the rationale behind this order is to facilitate, to allow the data negotiate with the creditors. Okay. So now, by chamber summons, notes of motion, originating summons. But be keen, you're going to have drafts. Oh. Okay. Okay. So, does the law state how we apply? Okay. So you go to Regulation 63 of the Insolvency Regulations. It tells you how we apply. Okay. Regulation 63 tells you how we apply for the interim protective order. Okay. It is very clear for an interim protective order under Section 1. Okay. So now we're pretty sure that we have served the adverse party, okay, and court summoned us. We appeared for hearing, and the order was granted. So the first thing you need to understand, what is the lifespan of the interim protective order? Okay, what is the lifespan? You go to section 121, which says that the interim order ceases to have effect at the end of 14 working days. So it has a lifespan of 2 weeks, basically. Okay, 2 weeks, 14 working days. Okay, but mark this, they are using working days, not days. Hey, you will count weekends, you will tell us. Okay, and you have issues in the IA of right for no good reason. Okay, yeah, this act uses working days throughout, not days. So that means not all days are working. Then after, okay, the order has been issued, what are the effects of the interim protective order? What are the effects of the interim protective order? Okay, once you have that order, okay, how will you enjoy life? People can demand. Okay. Okay, what are the effects of the interim protective order? When you look at section 119, subsection 2. Okay. 119, subsection 2, it says, it gives all the effects of this order. I'm going to read for you just two. We shall. It is section 119, subsection 2. It says, during the period of which an interim order is in force in relation to a debtor, A, an application for bankruptcy relating to the debtor shall not be made or proceed. So that means You can sit and relax. No one can go to court. No one can go to court. You are protected. That's why I told you, if you get this order, you can sit near the person who is demanding you. You order for chips and chicken every day. Okay? You order your sania, you eat and keep quiet. Yes. Okay? So when you have any creditor, okay, and you have this order, you are at liberty. Okay? Yes, you buy your sania, you sit in front of that person demanding you. Okay? You proceed. Okay? Then another one, a receiver of the property shall not be appointed. No any other step can be taken against you. You are at peace. Okay? So that means someone can't just wake up and proceed against you. But you know, where an order is always there, the exception is you should get an order to overrule that. That means with leave of court, we can proceed against you. So now, the presumption is we have gotten our order, we are protected. So now, we want to go for what we call arrangement. So now let's go to arrangement. So these things are simple. But the way we are laying them out is exactly the same way you proceed when you're dealing with the company. Okay? So now, let's go to arrangement. Okay? When you go to section 125, it says, immediately after the creditors meeting under section 124, the proposed supervisor shall report the result of the meeting to court. Now, we understand arrangement. You don't need to rush. It is the simplest, but at the same time, a little bit hard. First, ask yourself, was that section amended or not? Because I saw your colleagues last year crying in the auditorium. Okay? They cried. That's why some of them they sold you. Why? The amendment brings any problems than how you think. I'm telling you. Okay? Your colleagues saw the question. They thought it was, they all went for wrong remit because it was a company. They applied yet it wasn't 9%. The last one, remember the first one was of banking. They were all upside down as well. Now the second one was, they were also upside down. Now they decided to just split. He had come to make a follow-up, okay, and the recap for the entire semester. They said you are not proceeding unless we agree. You're giving us one eye over them. He told them he's joking. You don't want to read, you will learn. But everything started from arrangement, because arrangement is hard. We have arrangement in the company and arrangement here. So differentiating the two is a little bit technical. So let's first understand this, okay? So how do we go? So let's look at what we call procedure for arrangement. Procedure for arrangement. Procedure for arrangement. Now, the first thing you do, okay? Now, you see, don't read these sections, okay, in isolation. The first thing you do when you are going for arrangement is to come up with a proposed arrangement. You make a proposal of the arrangement as you, the person they are demanding, who doesn't want to pay. Okay? You make a proposed arrangement. Why? It is the ground for you to, in your affidavit in support, you have to indicate that you have a proposed arrangement. Okay, so now after the proposed, you have come up with a proposed arrangement. The next step will be serving the proposed arrangement to a proposed supervisor. Why? When you go back to the law for an application, the grounds under section 120 subsection 2. We've not yet reached that same answer. Okay, those are ways we shall look at the later stage. Okay, we are still fighting so that we don't reach there yet. Okay, hey. Okay, so now we are here. So because when you look at section 120 subsection 2, it says the name, the debtor intends to make an arrangement, and where the debtor is undischarged has given notice of intention to a trustee of his or her estate fund to that effect. Okay, that the named supervisor, the named insolvency practitioner is willing to act as a supervisor. So that means you have served, okay, the intended supervisor. Okay, so now the presumption is the intended supervisor has received your proposed arrangement. What will the intended supervisor do? The next step will be calling for the creditors meeting. Now, the proposed supervisor is the one who calls for the creditors meeting, not you. Okay, that is under section 124. Okay, it wasn't amended. Okay, calling for the creditors meeting. So now the creditors come with your intended supervisor and your proposed arrangement. We sit and tell them, people, we know you're demanding, my friend. Okay, I know Hajat is willing to pay, but she has just financial issues. This year hasn't been good. So as a result of that, we have proposed the way of paying you as here under. Do you buy the idea or not? Then we start negotiating the proposal. Okay, that's the meeting. Okay, under 120/24. Okay, it's called the creditors meeting. Okay, are we together? Okay, now when you look at one of the duties of this gentleman, the intended supervisor, he makes what we call a report. A report, yes, after him reading through, okay, your proposal, he makes a report to court. Okay, and after he has made a report to court, he will call for that meeting. So from that meeting, we shall know whether the creditors have agreed or have not agreed. So where the creditors agree to the proposed arrangement, it will change from proposed arrangement to, are you together? Because it is now no longer a proposal. These guys have adopted it. But how does it become arrangement? It is upon being endorsed by court under 125, where we say arrangement order. You get it? So the outcome of the creditors meeting under 124, it's what the supervisor now, because he's no longer a proposed supervisor also. What happens in the creditors meeting? Once these guys agree to your proposal, the first thing they do is to drop the proposed supervisor. Okay. Now, let me give you an example. When you, they are two best friends, okay? Her boyfriend complains to her that I don't understand her yet nowadays. She doesn't pick my calls. When I send money, she doesn't respond. She knows that this person has someone who is bypassing you. Do you think she will stand firm against the colleague that, you know what, sit down, your time is done. We have a new potential client who pays in dollars. We don't need to ask for money first. They just send. Okay? You get it? Okay? Why? These two are friends. Okay? Because I saw her through her. So that means whatever good or bad, she's aware. Okay? So now bring that very aspect to insolvency. The creditors are not there when you are appointing your proposed supervisor. What if you choose your best friend? What if you choose your best friend? Remember, the intention of the arrangement is to put the intentions of the creditors to a forefront. So if they leave the proposed supervisor whom you appointed, this person will not put their interest at the forefront. So what they do, they first drop the proposed supervisor in this meeting in the first place, and then they appoint a supervisor. So if you are lucky, you'll be appointed as the supervisor. If not, they will appoint someone else, because those are powers of the creditors. They're just helping you agree to your proposal. They are just helping you. Okay? Proposed. Once they agree to your proposal, they drop the proposed supervisor. Now they are another one to court. Then court will endorse it. Arrangement order. Then the right to disagree. You don't have cancel. The fact is, you are broke. Okay, these guys are just helping you. So you want to bring your case. You're disagreeing, and they have the right to disagree with your proposal. So once they agree, you proceed under 125 and go to court, and then court will endorse and it will become an arrangement order. But where they disagree with your proposal, you do what we call an application for extension of the interim protective order. Once you get a disagreement in this meeting, don't relax. Remember, 14 days will expire. We don't have time to play with you. Okay? But remember, you are representing the data. You shouldn't give the data should be sleeping peacefully because he or she hired a good advocate. Once they did, you see another these guys are disagreeing on your proposed arrangement. Rush back to court. You say, we are intending to go into further negotiations. Please extend for 14 days. They add you time like that. Okay? Yes. Exactly. Yes. Okay, what happens? Okay, the main duty of the proposed supervisor is to call for the creditors meeting. After executing his obligation, okay. Once they agree, they may not. But chances are high they drop you. Now, I was just giving an example. Okay, but a supervisor is what we call the insolvency practitioner. All insolvency practitioners are advocates, guys. You look at the definition of insolvency practitioner and their rules here. They are there. Okay, so are we together? So now we have gotten the arrangement order. We have it now. So what are the effects of the arrangement order? Then you go to section 127. Okay. So the same effects we cited, the interim protective order, they are the same here. They don't change. No insolvency proceedings should come against you. Okay. Nothing. Okay. They are okay. They're like subject to subsection 3. An arrangement binds the individuals in respect of whom the arrangement order is made. Then B, the supervisor of the arrangement. Then C, all the individuals creditors for claims arising on or behalf the debt specified in the voluntary arrangement. So the first thing, it is binding to all the parties. Now they will give you facts. Mark this. You may study this. You can't show that they are testing effects. They'll give you facts. Going to draft insolvency. These guys were in arrangement order. They tell you discuss the effects in the facts. We leave that I. Okay, you get it. So now, are we together? Okay. So now, after that, okay, after that, we've seen the effects. We read 127 in its entirety. Okay. Then after, okay, you look at variation under 132, how we can vary this order. Okay, we can be trapped. It's an agreement. Then how it can be terminated. Okay. And okay. Then you go to 134. So now, what happens where that refuses? If you violate the arrangement, what happens? The creditors will have an upper hand there. Then they can take you for what we call the creditors petition for bankruptcy. We are dealing with an individual. Then we go to what we call bankruptcy. You can't go to bankruptcy when you have not exhausted those remedies. Why? The law hates bankruptcy proceedings. Because once we declare you bankrupt, how will your family survive? You can't contract, you can only contract with your wife at home. Okay, so where these remedies don't work out, the option you are remaining with is bankruptcy. These are two. We have what we call individual bankruptcy and then creditors bankruptcy. Individual, when you yourself, you say, my dear, connect what? Okay, or creditors. So where individuals, what we call voluntary petition for bankruptcy. You voluntarily, you go and file a petition against yourself that, you know what, Sike Sovola. Okay, no, it's here. Okay, so now let's look at the bankruptcy petition. Let's go to bankruptcy. Okay, so now there are things that you should put into consideration. Okay, let's go to section 20. Insolvency Act. It says petition for bankruptcy. Okay, so you hear the wording, you'll see that the wording is not petition court. That's what the individual, you, the data you may petition court, but the procedure where you petition court yourself that me additional one. Me and the financial situations in Uganda, we are no longer friends. Seems we quarreled. Okay. Okay, so we go on. Okay, it says that a debtor may petition court for bankruptcy, underline the word in your act, alleging that the debtor is unable to pay his or her debts. You underline the word alleging, so they can ask you for the procedure for voluntary bankruptcy. Okay. It's about that means we have to really ascertain whether it is true, because some people disguise under that when they are totally okay, you get it. It's a game that rich people know how to play, because we have time. Time expires and that order disappears. Yes, we are going to see here. Okay, everything is under the door. Okay. The years end, the order ceases to have effect. You gain yourself back. You start contracting the way you used to. Let's go on. Okay, so it says alleging that he or she is unable to pay his or her debts, the court may, subject to section 21 and 22, make a bankruptcy order. Whenever the section says subject to, so that means that is the procedure court goes through. Okay, so when you open section 21, it is very clear, statement of affairs. So what does that mean? Once you draft your petition, you attach a statement of affairs. How? These are my debtors, these are my creditors, these are my assets. So the assets should not outweigh the creditors. Okay? So what you should make sure, the creditors are 2,000, the assets are 2. And once they go for valuation, the value of the assets should not exceed the amount that you are being demanded. So when you are making the statement of your affairs, know how to steal, know how to Okay, so you should make sure when you are making your statement of affairs, consult an accountant to show that the fact is you are badly off. You can't even resurrect, even if when Jesus comes back, you can't. But a mere suspicion that you can resurrect, court will not grant. Okay, so now after you've made the statement of your affairs, remember you put the creditor, the location, and the contact. So what will the court do? Section 22, they do what we call a public examination. They call all your creditors, they publicly examine you to see whether you are lying or not. Yes. They call the creditors to ascertain the truthfulness of the allegations. What if you made some creditors who are not in existence? Okay. Do you know what they call validation? Those working entities, they know validation has been taking place because most of government entities have been paying ghost workers. So they have been doing what we call validation. Okay. So now has done what we call public examination. In most cases, what court does, they also proceed under 23. Okay, they make an inquiry on your dealings. Why do they make an inquiry? Okay, we have what we call, there is a certain type of transactions, what we call void transactions. Some people, because they know once they take the matter to court, they will start doing what? Transferring the property to someone. Once the matter to deal with your property. So any transaction in regards to that property is a void transaction. Okay. So now, after court has done everything, then court can proceed and then they declare you bankrupt. Once they declare you bankrupt, court will appoint a trustee. In individual, we don't appoint a receiver. Receivership is in company. Here we appoint a trustee. Okay. So then after that, the trustee will convene the creditors meeting. Simple as that. So now let's declare you bankrupt. What are the issues? Section 27. Upon making a bankruptcy order, A, the bankrupt estate shall vest first in the official, receiver, and then a trustee without any conveyance, assignment, or transfer. Okay. Now someone is asking now, Cancer has said here we don't have a receiver. Now we are hearing the official receiver. Who is in company? Who is the official receiver? The register of companies is the official receiver, except in matters relating to banks. Okay, in banks, the official receiver is the Bank of Uganda. We shall deal with that when we're dealing with companies. Now here in individuals, who is the official receiver? Is appointed by the act defines. Okay, in the interpretation section, it's very simple. Okay, so now then other effects, except with the trustee's written consent or with leave of court or in accordance with such terms as court may impose. One, no proceedings. You imagine, you hear these privileges. One, no proceedings, no execution, no any other legal process may be commenced or continued, and no distress for rent may be levied against the bankrupt. Yeah. So that means if you are a tenant, when I've been demanding you, please, I'm not supposed to demand. I stop there. You just move out, you don't pay. You've been declared bankrupt. No proceedings, no execution, no distress for rent. Except with consent of a trustee. That you want a trusting identity. Simple as that. So what is hard in insolvency? Okay. Then, okay. Then, section 20, subsection 1 provide for what we call the debtor's petition for bankruptcy, or what we call the individual's petition for bankruptcy. You voluntarily. Okay. Yes. Then section 20, subsection 2 provides for another one, what we call the creditors. Okay. The first one has been for the you then will have where the praise upon failure by the satisfy the statutory, the petition for the creditor. Okay. By the creditor or a debtor, and the court may subject to 21 and 22 makes that order. So you see, so the once we serve you with our cardinal notice and you don't respond, now with the creditors we shall come in. But the question is, do you know how to draft that petition? They are back. Remember our first week of civil modes of commencement of suits. Yeah. Hey, we had petitions. Okay. We had petitions, but please, members, mark this. We read the act alongside the rules, the regulations. Okay. But these things are straightforward. Okay. They're not, okay. Then all the documents are here. All the documents are in the regulations. Please mark this. All the documents you need are in these rules. Don't draft a document from Emma. Don't draft a document from your firm. I'm being honest with you people. I've always told you this. Once you enter that paper, leave alone this IS. If you've smuggled illegal materials in the IS, but the pressure that will be there in that corporate paper, you'll see all the stakeholders on board than ever. That's the paper that everyone wants to see you doing. I'm telling you. You will see all BAs on the ground that day. You're going to take a bag of compendiums. Some of you see people, some will exaggerate the matter, will come with briefcases here. I'm telling you. Okay? But with all that confusion, you read the question, you see that it is a petition. But because you aren't original, you have the petition in your book, but you look for the Holy Spirit to transfer the content from the exam, from the book to the answer booklet. You are seeing it like this, but feeding it. Why? You already got the petition when it has the content. So because this is the last minute you have to learn drafting. Okay? This is the only time you have. Don't rush. Don't rush. Go sit home. Open the rules behind. Ask yourself, what document I need? You say, let me first draft a demand notice. It is here behind in the rules. Start with the notice, go to the notice of motion, everything. It is in the rules behind. You try it out. You're going to get stuck in an exam. Let me tell you, you see that you people are complaining about time. 90% of you will not finish the final exam. Why? It is going to be because you are at liberty to take all the nonsense you want. Now, once you get in there, you say, I have my bachibinga. I have my bench book. You've never read it. That's the first thing. Okay? You say, I have my Mukuba, love banking. Mukuba doesn't have you. I'm being honest with you. Take things you know. Because what matters in that exam, knowing what to do. Me, I'm being honest with you. I was in the library with Honorable. The first it was library. I couldn't leave. I'm so obedient. Corporate like the corporate paper library Victoria because my idea. When I decided to go in the auditorium, they had to put me in front alone. I felt like now it is me and the Holy Spirit. I felt now I wish I said it in the library because I had but imagine sitting in front of you. So I had was me and my head and the Holy Spirit. Okay? Because me, I fear asking people. It's not pride, but I fear asking for answers because I know. I believe I'm the only person with the right answer. Okay? That's the first thing I know. You see, when you ask your neighbor, some of you lost right answers. And after say, man, that girl Aisha, so to avoid that, sit, get this act. Okay? You see, an exam is very simple. Once you realize the right document, I used to draft documents first because you look at the marks of the document, you feel like you need to draft documents throughout, but start on the document. You realize that your head is empty. Okay? But what brings that? People don't practice. Me, once I read the paper, I said, okay, because for corporate and commercial. It's my question. Because they gave us an exchange and not so the best evaluated bidder. So our question required administrative review. Once I read like this, I counted the days and said I'm within time. I just opened. The document was in my head. I looked at the act like this. I said, okay. Because I read the facts, I know the facts of it. So I could draw from here, just, but now imagine, you've not understood the fact, you don't know the documents, and you'll see the category. So to avoid that, kindly do this. You see these weeks, the fact is, not so good. You just like what you're supposed to do. Understand your work as you understand the work. Many of you have notes that you don't even understand. I can tell you that what is your book of plan? I tell you, when did you do fraud? You start from mortgages. As now look at this person. You don't even understand your book. When an exam comes, you just do like this. After reading the question, say it is all okay. You start writing, you just prepare. Okay? So don't lose track. That 1 week, I'm assuring you, it has magic. You can change everything. You can, and people say, but this there is no success. They'll chop your money for no good reason. Okay? So you people read. Okay? So now you should appreciate how to draft the same. Okay? Okay? So now, do we need to look at the petition? We shall look at it. Okay? Can have the workshop? Okay. Yes? Now, I'm looking at something. One, it's a mess. You people. So let's go to the facts of workshop 1. Your workshop is huge, yeah? And how you expect. Let's go through the facts, okay? These facts are technical than how you think. We first pause, look at the company issues, eh? We first pause. Or we do everything, we leave the facts. Okay? Yes. Cocoa, let's go. And his Chejo owns an 8,000 square foot commercial condominium floor in Kampala city center. They purchased the floor in Jan 2017 at $2 million US using financing that Cocoa got from the then youngest bank in Uganda, Penn Bank. The loan is repayable in 7 years, a monthly installment of that, and is secured by a mortgage of and personal Mulimi. He also got short-term loan of that amount payable in 12 months to enable him renovate the property for occupation. The two loans were eventually, his total loan balance is $650,000 US, including accumulated interest at the time payable in 7 years at a monthly installment of that each. The 80% of the condominium was being rented by one tenant, Major Supermarket, a retail chain store operating in Uganda. Major Supermarket was paying rent of $61 million per month, inclusive of all of which was 20% of Cocoa's net salary. Cocoa projected that with other tenants occupying the rest of the space, would raise the loan installment with ease. At the time, his father business, Mulimi and Family Enterprises Limited, as the general manager, Cocoa was entitled to 50 million gross salary a month. Cocoa also committed revenues from the consulting business, which 10 million per month. Senior supported in the business development. You see, that's just his financial position. So we don't know whether he used it, whether everything is still. So the first paragraph, okay, telling you that at the beginning of COVID-19 pandemic in 2020, Cocoa was convinced by his friend Penda that there was high market in mint plants, both local and export. The mint was the primary ingredient for COVID medicine, and the profit was almost over 200%. They agreed to form a limited liability partnership for this project and registered it as Cocoa and Panda Partners. What do you see in that? They are still individuals. Please mark that. Partners. It's a partnership. It has no corporate personality. Mark that. Partnerships are treated as individuals. They needed good agricultural land and seeds to start planting at a total budget of approximately 500 million shillings. Panda raised 250 from his NSSF savings while Cocoa had no cash. In July 2019, a 7-year lease of 100 acres from the foreign company that was leaving Uganda. Panda made a down payment of the 250 and the balance from Cocoa was to be paid in January 2021. Cocoa withheld 2 loan installments. Cocoa withheld, underline withheld, okay? Withheld 2 loan installments by picking 2 months rent and hold his salary to deposit on the land so that Panda feels better. The source of problems now. The foreign company directors were kind enough to allow the partners to take possession of the land immediately pending payment of the balance. However, they needed starting capital of 150. Cocoa asked Jenna to borrow them Uganda shillings 20 million from Wala Sente, a known money lender, on his behalf, which she did, and pledged her Twitter account as security. Okay, start counting all those are creditors. We have this Wala Sente, okay. We have this company that was leaving, the company that sold them land, okay. We have the bank. All those are creditors. So what happened? They also sampled the market and took the meantime, Cocoa convinced Panda to incorporate a single member company and to use it to apply for the agribusiness loans with government is extending through Uganda Development Bank UDB. Approved a loan of 1 billion for them. Bring UDB now. Okay. They used this money to purchase seeds and provide for other farm inputs. Immediately, they started to clear the land and they received a letter from the police stopping any activities because police complaint had been filed by the family claiming that the land was their customary land and that the lease had been fraudulently created. Yes. The family had lodged a caveat on the titles, white page, and applied to the resident district commissioner to intervene. Now no land. So problems start. Okay. For over a year, the engagement with the customary land claimants are back and forth. They insist that the partners should pay them for full value of the land or leave their property. The local authorities support the customary land claimants because the partners did not consult them before they paid the land. Pendo is losing patience because he invested more money and considering suing Cocoa, who is now accusing of conniving with the vendor because one of its directors, Pendo's old acquaintance. The herbalists want the mint or a full refund of their money with interest. Now talk about the herbalists also. So their money. In December 2021, a water pipe passed into the supermarket, flooding it and causing damage of the goods and other property. The supermarket immediately terminated the tenants and demanded for compensation for the loss. The supermarket owners immediately sued Cocoa and obtained judgment in their favor for 2 billion. Underline judgment. You see now where we're coming from. Judgment amounts to what? Including damages. They have since filed an application for execution of the judgment by attachment and sale of the condominium title. The bank which now execution. So you go to section 4. It amounts to a demand, a statutory demand. Okay. The bank which had already flagged his account for missing 2 installments is now up in arms with the development. They do not trust Cocoa anymore. They issued instructions to their lawyers to take the necessary steps to recover a loan outstanding now at 2 million. The bank has also issued a call on senior personals guarantee. The condominium is currently estimated to be of 2.8 million. It's the only property it has, mark that. So you should go back and add all the loans and you see how much are they demanding here. You get it? Because the loans should exceed the value of your property. Okay? Cocoa is talking to several other local supermarkets to take up the space, and some are very good prospectors. However, many are worried about the safety of their property due to a previous pipe burst incident and the possibility of the bank foreclosing after they pay their rent in advance. So now this statement shows he has hope of getting money. Okay, that he is okay. He's talking to other local supermarkets, so they may take it, they may. So that means if they take, he is likely to pay. That is okay. It points to what? Arrangement somehow, some. Okay. Cocoa has not been paying the tax on his rental income on the understanding that since all the rent is paid to the bank, it is not part of the chargeable income for income tax purposes. He has also filed VAT returns for the last 3 years. URA has issued a tax assessment of 3 billion. URA is also a creditor. Okay, secured creditors now. Okay, for these transgressions and demands that the immediate payment of these monies, the money lender, the money lender impounded Janice Kakaundo a few weeks ago, leaving her devastated because this was a birthday present from her late father. She wants Cocoa to pay the money lender immediately. You put Jenna and the money lender, they are also creditors. The herbalists have sued Penda and Cocoa for the refund of their money. They have also filed a police complaint for obtaining money by false pretense, among other charges. The fear of prison. Listen, the fear of prison led Cocoa to sell land he inherited from his grandfather in Masaka at 15 million to raise some money to pay off the herbalists. Okay? The land was worth 30 million on the open market. Cocoa paid the herbalists 10 million out of the sale proceeds. But the herbalists are dissatisfied. They want their money to be paid in full with interest. So they still what? Demand. Are you seeing existence of insolvency situation? Okay. Now there's furthermore, because of all these amounting pressures, Cocoa has not given adequate attention to his father's business. As a result, it has suffered losses for the last 3 years. All the pieces of land they bought since 2009 have not been sold to generate revenues. As such, the company has lost 10 billion, locked up in real revenues and real estate. Because of the business's inability to generate cash flows, it is unable to finance the operating expenses of approximately that per month. Employees have not been paid for 2 months, and staff morale is at its lowest ever. Several suppliers have not been paid for months, and consequently, staff have had to find their way or do without internet, stationary break, etc. Because the company has not been filing returns, URA has continuously assessed taxes based on the estimates, and the current tax liability is 6 billion for all tax heads. Senior is worried that URA is going to distress against the company. Senior and Cocoa have been advised by the family friend to protect themselves and transfer any properties in their names to third parties such that creditors find nothing. Look at that. Transferring properties. This, what do you call this? Void transactions. Okay. To his brother Kofi, Senior has decided to borrow some cash of 90 million from the money lender to pay half salary of the employees to calm the impending strike. He is confident they will accept this offer, as a fair number of them are good-hearted and they would not embarrass him. Senior plans to secure this loan by creating a mortgage over his home, which is estimated at 700 million. So now, here they have summarized for you the things we've read, okay? The liabilities and everything. Now they are saying task 1, investigate whether there are any insolvency situations and what may be the cause for it. Explain to Cocoa Mlimi the meaning of the difference between flow insolvency and balance sheet insolvency. That is accounting and taxation. So, okay, but don't worry. Discuss the corporate rescue, both formal and informal. Now, you differentiate between corporate rescue mechanisms and then no. What topic did you have in company last? No, you've never done corporate rescue. I'm saying company. After meetings, corporate financing, you differentiate the two. Huh? Now, that's the reason why I didn't handle company. We didn't have, because I want when you have the loads. We won't have another session for companies tomorrow, so that we'll cover both workshop 1 and workshop 2. Okay. So now, what we call corporate rescue mechanisms, that's what we call arrangement that we look at. Interim protective orders, setting aside. We have others under the Companies Act, okay, that we have compromise. We have amalgamation. We shall see them in the Companies Act, okay. We have administration. We have provisional administration. Those are under company. The reason they are saying corporate, that means they're referring to company only, okay. Then, what interim protective measures are available to Mulimi and family enterprises? Okay, to Mulimi is an individual. Okay, then you go for, we have the interim protective order, and the arrangement. Then identify the assets. Here they're looking at what we call the okay. Yeah, someone has told me what's happening. Okay, so now when you look at all this, okay, don't worry about these tasks. Okay, we are going to handle all these tasks tomorrow as well as with workshop as well. But what you should note, workshop 1, why is it tricky? It has 2 things. It has 3. It has individual for an individual like us. It has partnership within, which is also treated as, and it has elements of company as well. But whatever is in workshop 1, we don't go for petition. We are looking for what we call rescue mechanisms only. How we can survive the danger of being subjected to insolvency proceedings. So, in your free time, kind of help me and read section 234 of the Companies Act. Okay, read that. You help me with the case of Grain Bank. I know that's on your reading list. Also, in your free time, you can Google about Greenland Bank. Okay, in your free time. Okay, if you okay, I'm looking for the authorities attached here too, but I'm not seeing them. Eh? That is the okay. So kindly read case number 4, Still Pareri and another versus Spain Bank Limited. Okay, take your time, read the case of Teddy says chair bankruptcy. And that case is both in criminal and where you read Teddy says chair, not so? You've never read that case. Okay, Teddy says chair, it is for voluntary bankruptcy. She applied. Okay, then you read the one of Pareria, it's for company. Then you read Crane Bank versus Sudiru Pareria and another. Okay, civil appeal. Okay, those are 2 different cases. Then now, those doing corporate governance, read case number 47, Lehman Brothers International. Read that case. Okay, it is going to help you understand the entire corporate governance and this topic. Okay, I did corporate governance. Okay, it was my category C because I want corporate. Yeah, so I did corporate route. I couldn't associate myself with anything. So read 47. I know it is a bit tricky, but I know you will appreciate the same. But I assure you, this is the most easiest. You know why? It has been structured in a way that is good. Okay, so that was for today. We shall have another session tomorrow, inshallah. Okay, so okay, but I think it should be physical as well. Yeah, it will be here. We start at what time? At 4 or 5? At 4? Okay, inshallah. Okay, let's meet at 4. Inshallah. So, assalamu alaikum wa rahmatullahi.